Hi, welcome to another episode of Orrick Live. Today we're going to talk about what is probably the first financing event in a startup's history, and that is what is commonly referred to as friends and family financing round and angel financing. So today with me to discuss these topics is again John Bautista, a partner in our San Francisco office. And viewers of the show will be familiar with John. So John, thanks for joining us.
Thanks, Aria. Glad to be here.
So John, I say we dive right into it and talk about what this exciting first financing event is, Friends and Family Angel Round. Now, before we get into it, is there a difference in your mind between Friends and Family and angel financing, or is it just same thing?
It's pretty much the same thing. Friends and family is exactly what it sounds like. Friends of the founders, family members of the founders. They may not necessarily be professional investors, whereas an angel financing refers to a similar financing round, except the investor in that case, or the investors, are professional angel investors, either individual angels or institutional investors who have a network and who typically invest and have a track record of investing in early stage companies. So many times with friends and family, it could be their first or second time only investing in a high growth tech company.
That makes sense. That is exactly what it sounds like. So a lot of times when I have worked on these financings, I can kind of break it down into three varieties, really two, and then maybe theoretically a third one. So a lot of times I see people using what's called a safe instrument. And then sometimes you see convertible notes. And I guess theoretically, you can also do it as a priced equity round. So I think we should talk about all three of those. But since safes are most typical, why don't we start with that? Will you please just briefly maybe explain what a safe is and what some varieties of safes are?
Sure. Well, safes have become very popular. They've been out for more than 5 years now. SAFE means simple agreement for equity. And we at Orrick collaborated with Y Combinator in writing and developing the safe, and actually went on a couple of road shows to venture capitalists to explain back then what the safe was all about. But most companies today, in terms of their first financing round, are raising their first capital in the form of safes. They've become the standard. The YC form has become the standard. And there's really two different varieties of safe. One is a safe with a valuation cap, and the other one is with a discount. And what a safe is an agreement between the investor and the company, whereby the investor puts money in the safe document, which is a 5 or 6 page document, and the company takes that capital and agrees that that capital will convert in a future financing round for the company. And the conversion price is either determined based on the valuation cap that the company and the investor agreed to, or is a discount to the future preferred stock price when that safe converts.
I see. So it's kind of the investor and the company decide that they don't really know what the company's valuation is, but they decide on, we'll give you the benefit of not ever converting at higher than this valuation, or you will convert at this discount in exchange for having put in your money so early for taking the risk.
Correct. And that's a great thing about the safe, is you really don't need to determine the valuation. The valuation cap simply says if the company raises a financing round, let's say it's Series A round at a 20 million pre-money valuation, and the safe had a valuation cap of 10 million, then the safe investor gets to invest in the Series A preferred stock at the 10 million valuation cap equivalent versus the 20 million. So it's basically a 50% discount in that example. But if the company's Series A valuation is 7 million instead of 10 million, then the safe investor gets to convert at the 7 million valuation. So they convert at the lower of their valuation cap or the Series A valuation. And then on the discount side, if the company and the investor had agreed upon a 25% discount and the Series A valuation is 20 million pre, then the SAFE will convert at a 15 million pre-money valuation, i.e. a 25% discount to the 20 million pre-money valuation.
I got it. Okay. And, I've been lately hearing more and more about this, something called a most favored nation. It's probably because Y Combinator has started offering a most favored nation form of the SAFE to its cohort. Can you tell us a little bit about what generally that is and how that plays into this equation?
Yes. Well, most favored nations or MFN provision only benefits the investor. So many investors will ask for it. If I'm on the company side, I'll try not to give an investor an MFN provision. And what it says is that when you buy a SAFE, if a future investor in a SAFE has better terms than you as the investor, then you have the right to, in a sense, exchange your SAFE for the better terms. So if you bought a SAFE with a 10 million valuation cap, and then 3 months later, the company sold SAFEs at a 7 million valuation cap, then you as the first SAFE investor would have the right to the 7 million valuation cap.
Okay, got it. So kind of lets you see what happens next, and then the investor gets the benefit if somebody else hits a better bargain.
Right.
I got it. So, and then I think you mentioned this, but just to kind of put a fine point on it, the end game for a SAFE holder is to end up getting shares in the company, correct?
Correct.
So at some point, this SAFE turns into equity, and I believe what you said is that happens most often at the next financing.
Correct. So in most cases, the company has raised its first capital, whether through friends and family or angels or both, in the form of SAFEs. And it can be done over time at different terms, different valuations, different discounts. But what happens to all of these SAFEs at the time of the company's first preferred stock financing is they convert into the same series of preferred stock that the company has negotiated with a venture capital investor. And those SAFE holders will receive all the same rights that the future investors, the venture capitalists, will receive, except for rights like board attendance or rights that depend on the number of shares that the investor receives, such as pro rata rights or other major investor rights. But for the most part, the benefit to the company and to the early stage investors, they're piggybacking and writing off of the future rights that the company negotiates with its future venture investor.
Got it. And what happens if this company is sold somehow before it raises a first round of venture finance?
We've seen that happen sometimes, and the SAFEs would not have converted in that case. The venture financing hasn't happened yet. In that case, the SAFE investors are treated as if they were preferred stock, having a priority over common stock. And what that means is they have the first right to receive their money back. And if the company sold for a value greater than the valuation discount in the SAFE, they'll receive additional value as if they had converted at the valuation cap. Or if there had been a discount in the SAFE, then they'll receive a rate of return on their money equal to that discount. If the company does not succeed and there's not enough money to distribute to the SAFE investors, then they receive their money back on a pro rata basis based on the amount of dollars that they invested in the company.
I got it. So they're entitled to some upside on a sale of the company, and they have some downside protection for having put their money in. That makes sense.
Exactly. Yeah, which is one of the reasons that SAFEs has become so popular, because they have that upside benefit in a sale of the company before a venture financing. They have downside protection on the same basis as if they had been preferred stock in the company. And they have this ability, or the SAFE will convert in a future financing round on the same terms as the venture investor who spent a lot of time negotiating will convert into that future financing round. So it's a good deal for the safe investor, but it's also a good deal for the company because the company can raise capital in a very fast, efficient way. And providing that the company is using a standard form like the YC form, many times the company doesn't need legal counsel to raise capital using SAFE. So it's incredible cost savings for the company as well.
That's right. I think services like Clerky right now can just pump out these safes, and even Carta for those companies that are on Carta platform already. So it's getting easier and easier to do it.
Yes, and Clerky was one of the first legal service providers to make available to its customers the ability to raise capital via safes and clicks right through to the YC form, and also provides the A to Z process for companies to engage with the investors as well as have the money wired to the company's bank account. And there's other services, as you mentioned, Aria, such as Carta right now that offers something similar.
Fantastic. That's great. So that covers up safes, I think, pretty well. Let's talk about convertible notes as well, because I still am seeing them. I imagine your experience is the same. So what is really the essential difference between a convertible note and a safe? And what happens if a company raises money using convertible notes?
Right. The main differences are twofold with the convertible note. A convertible note is debt. It is a note, and therefore there's interest that is either paid or accrued. And the second main difference is it does have a maturity date. So in theory, after a period of time, whether it's 12 months or 36 months, if the financing round for that company has not happened, and if that note therefore has not converted into equity, in theory, the company would be required to repay the money to the note holders. Now, in most cases, we see some renegotiation if a financing round hasn't happened in order to give the company additional runway for that to happen. The other thing I should mention is in convertible notes, it's usually negotiated what the threshold size of the financing needs to be in order for the note to convert. Unlike safes will convert in any preferred stock financing in the future, but convertible notes, investors usually want to have a minimum threshold round size before their notes will convert. The other thing I should mention is there's no industry standard form of convertible note, whereas with safes, again, the YC form has become the industry standard. What this means is that convertible notes usually lead to more negotiation between the company and the investors, and usually the company needing to involve legal counsel on its side and the investors' legal counsel on their side to complete the convertible note.
That makes sense. So convertible note, it just seems like it takes a little bit longer, but I suppose the reason to do it is if an investor that you want investing in your company is asking for it. Is that right? Is there another reason to do it?
That's the main reason. It wouldn't be to the company's advantage to issue convertible notes. From the company's perspective, it's better to issue safes because safes are convertible equity instruments versus a convertible note is a convertible debt instrument. But many investors who are not used to investing in safes or who want to be in the position of a creditor as opposed to an equity holder will insist on investing via convertible note.
Got it. Yes. So that covers that off. So it sounds like it's pretty much like a safe, just a little bit more complicated, a little bit more customizable, probably requires more expert attorney review, but ultimately gets you to the same point, which is to raise the money without having to decide evaluation.
Correct. Yeah, and that's a good point that convertible notes can be structured just like safes where they would have a valuation cap or they could have a discount. They can also have MFN provisions as we discussed earlier.
Got it. Okay. And then let's talk about, maybe this is a theoretical case, but we can quickly cover it. Do you see any companies at this very early stage when they're raising angel or friends and family financing to use equity to actually issue stock to the investors in exchange for money? And if so, is it a new series or is it the same kind of common stock that the founders get?
Short answer is usually not. And usually we encourage companies not to sell preferred stock in their first financing round, their angel round, or their first friends and family round, because it is more complex. It does require a lot more legal engineering, and the valuation gets set. So many times we don't see preferred stock issuances because there needs to be a discussion around valuation. In all cases, when there is a first equity financing round for a company, it's preferred stock. So it's a different series of stock, a senior series of stock over the common stock that's held by the founders and the employees. And because in these financing rounds, a new series of stock is being created, there's a lot of questions about what those terms are. And that's what leads to a lot of negotiations. So if a company is raising a couple of $1 million, it's usually not cost justified to jump right into a preferred equity financing. The other thing I should say is, in particular, if it's friends and family, there's usually not a forcing function around setting the terms. There's usually not one major investor who's going to set the terms. So it's another reason, in particular, in friends and family rounds, we don't see preferred stock being issued. If it's angel investors, many times angel investors will want to set terms. But again, what the company, in consultation with its legal counsel, should determine is whether that's the right size of financing to justify the time and expense to negotiate all of the preferred stock terms. And in most cases, with legal counsel, the company can convince the investors to use a SAFE or convertible note as opposed to preferred stock to do that first financing round.
Yeah, I think it highlights having good advisors around you and getting the right investors at the early stage can really set a company up for success.
Correct.
So what are, let's set aside this equity financing because that doesn't happen at this early stage as we just discussed, but for a SAFE financing or a convertible note financing, what are some corporate formalities just at a high level that the founders should be aware of as they embark on this path?
Yeah, usually you'll need to have your board of directors approve the SAFE financing or the convertible note financing. It's unlikely that the company could have contracts with third parties that require third-party consent, but it's a question that the company should ask: do I need to get the consent of anyone else to do the SAFE financing or the convertible note financing? But we don't usually see that to be the case. So simply getting board consent is important. Investors also, it's really important from the company in checking the box around the SAFE or the convertible note financing to make sure that its investors are accredited investors following the federal accredited investor rules. So we strongly recommend companies make sure that all of its investors are accredited, and also making sure that the company has not engaged in a general solicitation of investors. Really important that it be kept to people who are either professional investors or have a relationship, whether it's a family relationship or other relationship with the company, so that the company is not in violation of federal and state securities laws.
Yeah. As much as entrepreneurs like to do it, this is one case where you can't shout from the rooftops about how great your company is and how much money you're raising.
Don't tweet that you're planning to raise capital, and encourage people to reach out to you if they're interested in investing in your company. That's a big no-no.
Yeah, absolutely agree. And we have seen, I think, John, both of us, the kind of trouble companies can get into if they don't gather around these accredited investors. If they have non-accredited investors, it usually comes up, in my experience, when the company is about to be sold, and then the sale process gets a lot more complicated. But it could also, of course, result in securities law violations, which would be at least distraction to the founders as they're trying to run their business.
That's right.
And John, you mentioned something interesting about consent rights, and you have to always check what kind of agreements you have. One that I've seen kind of come into play sometimes is this thing called the pro rata right. Founders always ask, because investors always ask, can people have pro rata rights? What are your thoughts on that? I mean, I guess taking a step back, what are pro rata rights, and what is your general kind of guidance to founders who are considering granting it to investors at this early stage?
So pro rata rights are rights that investors ask for to secure the contractual right to invest in a future financing round. They're also known as preemptive rights or participation rights or ROFOs. So you will hear all of these terms used interchangeably, but essentially they are all the same thing, which is the right contractually to participate in a future financing round. And it's usually determined based on the investor's percentage ownership of the company immediately prior to that financing round. So for example, if an investor owns 20% of the company, and the company's then doing a future financing round, the investor would have the right to buy 20% of the shares sold in the future financing round in order to maintain that investor's percentage ownership in the company. And that's usually the objective, is to maintain one's percentage ownership in the company. The pro rata rights get a little bit more complicated when we see safe investors and convertible note holders negotiating pro rata rights, because in that case, their percentage ownership of the company is really based on a hypothetical, which is what would their percentage ownership of the company be if their safe or convertible note had converted? And then that's the percentage that gets applied to that future financing round. So these pro rata rights are usually expressed in the form of a side letter. So they're not part of the YC form of SAFE, but professional investors will add rights. They will usually put in front of the company a side letter that contains their definition of the pro rata rights. And again, in the case of a SAFE or convertible note, there's room for negotiation as to what those pro rata rights mean. It could simply be as well, if an investor is investing $500,000, for example, in a SAFE or convertible note, a pro rata right could be, we as the investor have the right to invest an additional $500,000 in the Series A financing at the Series A price. So there's a lot of variability of pro rata rights when it comes to pro rata rights negotiated by SAFE holders and convertible note holders. Many times we'll also see in these side letters investors asking for other rights, such as information rights to receive financial information about the company or to inspect the company's records. And some investors who might be lead investors in a SAFE financing might also ask for board observer rights. So the right to be present at board meetings in a non-voting capacity, and to receive the same information that the company gives to its board, to receive that at the same time as the board members receive. So if as a founder, you're negotiating pro rata rights or information rights or observer rights, or if your investor is putting in front of you a side letter, it's really important in our view to have legal counsel look at those side letters, even if you're using a standard form of SAFE.
That's right. It can get complicated, and there are pitfalls. So I think we could probably talk for another hour about all the different things that can go in a side letter that we've seen, and all the war stories and the good stories. But yes, I think the overall message is, if it gets to side letters, it's probably getting complicated enough for legal advisors to be involved. Well, that's great, John. So it sounds like, at this very early stage, this usually founders and friends and family or angel financing usually happens right after the company just got organized, as they're really trying to build their MVP, or as they're trying to do some validation of their concept. At this stage, it sounds like really the point is to get the money in as efficiently as possible, as with the least amount of cost involved, which is why safes are so great. And then, after that, convertible notes are the better alternative. And then hopefully that is enough money to kind of get the company to its first venture-backed financing, and then really on the trajectory for growth.
Yeah, I agree with that order of priority, where safes are the fastest, easiest, and cheapest, followed by convertible notes, and followed by a negotiated priced preferred stock round.
Great. It's been a great conversation, John. Thanks for all your thoughts as always, and for sharing your time with us. We hope to have you back on future episodes here.
Thanks, Aria. My pleasure.